Good afternoon, everyone. Thank you for joining us for today's webinar session on the executive order, the financial and legal impact on payer contracts. We're going to give everybody just a minute or two to get settled in. I still see a lot of people signing in at the moment. So we will pause here for just 1 minute, and then we'll go ahead and get started with today's presentation. All right, well, again, welcome everyone. Thanks for joining us today. Just some brief introductions and housekeeping items before we get started. My name is Brad Josephson. I'm the Director of Marketing here at PMMC. PMMC is a leading revenue cycle management provider. And then with me today is Greg Kay, who is the Senior Vice President at PMMC. Greg's been in healthcare for over 30 years. And has been with PMMC for over 20 years. And also joining us today is David Chilman, an attorney who's the president of Chilman Law Firm. And David brings 27 years of experience representing healthcare providers and has extensive experience specifically around healthcare reimbursement. We're really excited to have both Greg and David's expertise today as we look forward to the new executive order and really look at what the financial and legal implications of that executive order are. So before we get started, we're going to go ahead and kick off today's session with an opening poll question. So if you would please respond to this question, and based on what you know currently, what's your biggest concern regarding the executive order? And the options here are the inability to provide out-of-pocket costs for our consumers or patients, the fact that we may have to publish contractual allowables, we currently are not strategically planning for upcoming changes, or we don't believe this will impact our organization. So again, that question is, based on what you know now, what's your biggest concern about the executive order? The inability to provide out-of-pocket costs to patients, the fact that we may have to publish contractual allowables, we are not currently strategically planning for upcoming changes, or we don't believe this will impact our organization. And we'll give everybody just about 10 to 15 seconds here to vote. All right, it looks like the majority audience has voted. So at this point, I'm going to turn it over to Greg Kay actually, I'm going to go ahead and introduce the agenda first. So the executive order was just issued a few weeks ago. And right now, there honestly are a lot more questions than answers. So one thing we do know is that the executive order is going to be wide-reaching, and it's likely going to impact many areas of your organization, from finance to revenue cycle to managed care to patient access. So the goal of today's session is to provide you not only an overview of the executive order, but also some questions that your organization and leadership should really start thinking about and asking in order to prepare for the impact. And as I mentioned, with both Greg and David on the call today, we're really going to look at this from both a financial and a legal standpoint. So Greg, can you start us off with an overview of the executive order and when this will take place?
Certainly, Brad. Everyone knows January 1st, all hospitals were required to post their standard list of prices or charges. On June 24th, President Trump signed an executive order related to pricing transparency. And in that order, by mid-August, the Secretary of Health and Human Services will propose a regulation consistent with applicable law to require hospitals to publicly post a standard charge information list, including both charges and information based on the negotiated rates and for commonly shopped items and services. This information will need to be in an easy-to-understand, consumer-friendly, machine-readable format using consensus-based data standards that will meaningfully inform patients so that they can make well-informed decisions, with also the ability to compare prices across hospitals. Now, the regulation should require the posting of standard charge information for services, supplies, or fees billed by the hospital or provided by employees of the hospital. Now, the executive order also noted that the regulation should also require hospitals to regularly update the posted information and establish a monitoring mechanism for the Secretary to ensure compliance with the posting requirements as needed. This process, as we know, started nearly 2 years ago, and Secretary Azar has consistently said the initial requirement, being back on January 1st, to post charges was the first step, and the subsequent steps are beginning to become more apparent. Now, within 90 days of the date of the executive order, the Secretaries of Health and Human Services, the Treasury, and Labor will issue an advance notice of proposed rulemaking, again, consistent with applicable law, soliciting comments on a proposal to require healthcare providers, healthcare insurers, and self-insured group health plans to provide or facilitate access to information about the expected out-of-pocket cost for items or services to patients before they actually receive care. It's important to note that the requirements may extend to payers as well as providers. Now, within 180 days of the date of the executive order, the Secretary of Health and Human Services, in consultation with the Attorney General and the Federal Trade Commission, will issue a report describing the manners in which the federal government or the private sector are impeding healthcare pricing and quality transparency for patients, and they will be providing recommendations for eliminating these impediments in a way that promotes competition. This report should describe why, under certain conditions, lower-cost providers generally avoid healthcare advertising. Now, everyone also needs to keep in mind that next year, 2020, is an election year. There's an old saying in politics that the cover-up is worse than the crime. At this point, we believe everyone needs to understand if you're not embracing and moving towards transparency, you're likely going to be setting yourself up for a potential target and likely find yourself in an indefensible position of hiding cost of healthcare services versus putting the information out and being transparent with healthcare services.
Greg, this is David Shillman. Just as a follow-up, since the requirement may extend to payers as well as providers, there is a chance that payers will want to try to control the narrative on cost and quality. And I'll speak to this in greater detail later in the presentation, but it underscores the need for providers to ensure that their contract language addresses this important issue.
Great point, David. Now, it's important to remember that our system of healthcare coverage today is based upon a balanced arrangement of three key players: payers, providers, and the patient, with the government being both a payer and a regulator. Now, the stated goal of pricing transparency is to introduce market forces around price and quality data by leveraging technology to ensure that the consumer easily understands the real-time cost of an anticipated service. Over the past 12 years, high-deductible health plans and HSA accounts have really grown in the market and has moved from really less than 5% in 2016 to over 33% in 2018. The goal of these plans, high-deductible and HSA accounts, are to really have lower premiums with higher deductibles, co-insurance, and out-of-pocket max. The basic economic principles with these plans have been to incorporate the concept of cost sharing. Now, remember that word cost, because as an out-of-pocket expense shifts from the insurer to the employer and on to the individuals, the underlying premise is that consumers will become more engaged with their healthcare expense, which in turn means a higher level of price shopping. As we all know, the patient co-insurance is really what ties the patient to your payer negotiations. Now, many would say that this economic model still remains unproven, as customers today choose healthcare services for a variety of reasons, and not all services can be easily price shopped. Now, the recent executive order is really pushing our industry to address the ongoing confusion around these three words that are so simple yet so confusing. They have completely different meanings for payers, providers, and consumers. Last year, CMS required hospitals to publish charges, and it was referred to as pricing transparency. In the healthcare field, we know that the reality of today's requirement is the retail price is really charge transparency. As a reminder, Secretary Azar noted back earlier this year and going into this new year with the January 1st requirement that was really the first step. And most everyone in the industry and probably on this call noted that while it might provide some insight, most knew it really wouldn't help patients or consumers know what it actually was going to cost them. The executive order is really propelling our industry to address the price and cost component. Now, in late January, PMMC surveyed the market to see how the industry responded to the charge transparency mandate. And as noted on the slide, in the gold color, we listed our results in January, and we resurveyed that same population of hospitals earlier this month. And you can see the results listed in green. We found some really interesting trends. As it relates to posting charges, we believe all hospitals met CMS's mandate, with a few organizations really bearing their list of prices. Now, as it relates to estimates, most providers included on their website a phone number to contact for an estimate. And this has been a great first step, but the executive order appears to be moving our industry towards a real shopping experience versus providing a phone number. The lower stat highlights the fact that a small percentage of providers today are really taking that next step forward and providing the ability to quickly and easily generate a self-service estimate from their organization's website. Now, it's also interesting to note that our survey found that healthcare providers are doing an exceptional job of making it easy for patients to pay their bills with online payment options, which I think speaks to the need for pricing transparency. We're doing a great job at providing options to collect money, but there are opportunities to communicate what is owed in a more proactive way that healthcare pricing transparency is really moving to address. As an industry, we need to embrace the fact that patients are becoming a critical payer group, and we believe CMS will soon be mandating these additional changes. Now, more specific to the June 24th executive order, President Trump has directed key departments, including Health and Human Services, Treasury, Labor, the FTC, and the Attorney General's Office to take steps to improve the transparency of healthcare pricing and quality information. More importantly, to ensure that it's easy to access and easy to understand. Now, as we all know, we can go online today and find the cost of 100 different TVs with different sizes, different means, whether it's LED, HD screens, different stores, different shopping experiences, whether it's picking up or having it shipped directly to me. I can go online and find multiple flights or travel arrangements with specific airlines, hotels, rental car agencies. I can search those separately, or they can be bundled together. As an industry example, we know there's a difference between freestanding and hospital-based services, both in terms of the charge, the price, or allowable, and ultimately what the patient is going to pay. In other words, their cost. Data is available today, but it's not easily found or easily understood. The executive order will lead to greater access to data, so the marketplace will drive the development of new tools for patients to understand their cost. Most healthcare providers have some means of providing cost and quality data to patients today. The coming change in the near future is the requirement for this data to be easily understood and available real time. As I mentioned a moment ago, HSA accounts were first introduced in 2003, and the balance of these accounts continue to double about every 3 to 4 years, with a projection of about $75 billion in value coming up here in 2020. As the patient financial responsibility grows and shifts that are occurring, there'll likely be an increase in the utilization of HSA accounts and other healthcare savings scenarios, such as high deductible plans, as pricing transparency becomes more readily available. Now, to respond to the first goal that we just outlined, healthcare providers will need to move to a more integrated charge and pricing strategy. So why do we say that? Well, here are a couple of reasons. CMS is requiring the posting of charges today and will likely be moving to require you to post the allowable and make it very easy for the patient responsibility in the very near future. Commercial payers and employers expect a discount, so payer negotiations will likely continue to stay very relevant. A recent United Healthcare Consumer Sentiment Survey also recently found that 36% of healthcare consumers price shopped online last year. And about 90% of the patients said they don't feel an obligation to stay with a healthcare provider who doesn't deliver an overall satisfactory digital experience. And that includes online bill pay, scheduling, and receiving an estimate. Now, as charge, price, and cost information, again, information, not just data, becomes more common, we're going to find that consumers will vote with their wallet. As previously noted, less than 10% of the hospitals in January and approximately 13% of those same facilities have online estimate tools today, and an even smaller percentage we found incorporated a real-time eligibility check. CMS and market pressure will drive providers to incorporate this type of technology going forward. As consumers select an anticipated service, it needs to tie back to your negotiated rates, which is the patient allowable for professional, technical, and combined services. You have to keep in mind this critical point of the payer allowable as you start to think about your payer negotiation process. Know what's being shopped, model your charges, your price or allowable with this in mind as you start to revisit your payer negotiations. As patients shop for services versus just being consumers of healthcare services, your charge, your price, can assist those consumers in self-directing based upon the distance or the price. For healthcare systems with various locations, whether it be hospitals, freestanding imaging centers, freestanding AMSURG centers, urgent care, your ability to connect with the price-conscious consumer is going to be even more important.
Yeah, thanks, Greg. That's great. And you just really gave us some key insights really to how to meet that first goal of improving price and quality transparency. So now I'm going to turn it over to David. And David, I'm curious to know, how do you see the first goal of the executive order impacting payer contracting?
Thanks, Brad. Great question. Managed care contracts typically contain language that states that both parties agree to comply with all applicable laws and regulations. In order to comply with these new laws and regulations, the contract may have to be amended. Many contracts will have language that provides for amending the contract to comply with these new laws. But providers have to ask who gets to decide that changes to the contract are necessary in the first place, and who gets to decide on the specific language that will be used to amend the contract. My experience is that payers typically prefer to control this process, as evidenced by the language in the contract, often giving them, quote, discretion to decide. So the first question, who gets to decide that changes to the contract are necessary in the first place, is important, because if a new law imposes obligations specifically on the provider, then the provider should have the ability to initiate the change. Payers obviously don't have the same incentive to change the terms of the contract if the law doesn't apply to them. And this could have consequences on the provider in terms of compliance with the law or potential breach of the actual contract if the changes aren't made. Or perhaps it's debatable as to whether the new law even requires the language of the contract to be modified. A payer could use the new law as an excuse to change the terms of the agreement in a manner that was not intended and that really benefits the payer. And this dovetails into the importance of the second question, who gets to decide on the specific language that will be used to amend the contract? Because if the payer controls how the contract will be amended, the language that's going in there, it's the payer that will get to draft the new language in its own discretion that it deems is needed to comply with the new law. Now, I've been doing this for many years, and let me just say that new language unilaterally inserted into a contract by a payer in this regard may go far beyond simply complying with a new law or regulation, and the provider should have a say in that process.
Thanks, David. And before we move on to and talk about the second goal of the executive order, I would like to mention that we're going to be taking questions from the audience at the end. I have a feeling there's going to be a lot of questions around the topics today. So please go ahead and enter those in the questions tab in your GoToWebinar pane as you think of them, and we will just hold them till the end and take them at the end of the presentation. So with that, we're going to go ahead and move on to the second goal of the executive order, and Greg's going to tell us a little bit more about that.
Great, thanks, Brad, and thanks, David. The second anticipated outcome or benefit of greater transparency is a well-informed consumer, when armed with available data and information, will make purchasing decisions based upon cost. As I mentioned a moment ago, today 92% of Americans have smartphones and use their phones for some type of shopping. We just wrapped up Amazon Prime Day, which was literally earlier this week, and they experienced record numbers again, and it just reinforces, as we're having the webinar today, that consumers are going online, they do shop and compare prices, and prices do impact where they go for services. Today, consumers shop and compare everything from travel to electronic, apparel, food, other goods and services. Healthcare is truly one of the remaining remnants where comparative pricing is not occurring. The ultimate goal with the executive order is to let the market drive competition versus a small group of individuals determining the winners and losers with healthcare providers. As patients become consumers of healthcare, again, versus just recipients of healthcare, our industry will see more disruptors entering this space.
Greg, are there examples of that currently happening today that you've seen?
Yeah, let's take a look at one that CMS rolled out last year, and this was their procedure payment lookup tool. CMS's intention is not only to increase pricing transparency, but also to be the catalyst for a new means of shopping for healthcare. Keep in mind, with CMS's procedure lookup tool, it's very simple at this point. It's their first release of this, and users can search by procedure name or code. Most individuals will not know the procedure code, but there's a keyword search similar to Google in that as we type in hernia, it provides a related list of procedure codes. And we would imagine over time, this tool will become easier and smarter as more individuals use this particular tool. Now, once a code is selected, as you can see on the right-hand side of the screen, users will see the average Medicare beneficiary's financial responsibility if that procedure occurs in an ASC setting versus a hospital outpatient department. CMS's goal is to provide insightful pricing information so patients can make better decisions for their health care and their wallet. In this particular example, patients and consumers will now be able to see the average cost difference, again, that being the average patient payment. This will likely lead to more detailed questions coming from patients and consumers to your organization. CMS also provides the ability to search for a hospital by zip code. So if I enter my particular zip code, it's going to bring up and provide a list of hospitals and link to the comparative quality data in my particular marketplace. Today, the price information is at a national level, but the quality data is down to the zip code level. It's our projection that the cost information, being the patient cost information, will be readily available as well at a zip code level in the very near future.
Thanks, Greg. And those are all good points about, I think, how quickly this has evolved. And as you mentioned, this is only the first release, so I think we can only expect it to get more sophisticated going forward. So I'm going to turn it now back to David. David, how do you see this goal of the executive order, empowering patients with additional information, impacting the payer-provider contractual relationship?
Thank you, Brad. That's a great question. And the fact is that transparency of pricing and quality is a powerful tool used to influence the patient selection of providers. The scary part about this is that it can be a powerful influence on provider selection by the member, even if information is inaccurate or misleading. So it's important to have contract language that addresses a number of things. So, for example, who controls the interpretation and dissemination of information regarding price and quality? And I don't want to digress from our topic by highlighting other important contract issues, because I could spend hours on that. But while we're talking about pricing, I just want to say that too often I review contracts and find that payers can actually unilaterally change how much the provider is being paid during the term of the contract. And believe me, I've reviewed hundreds of these over the years, and I used to draft them when I was on the payer side. It isn't always obvious. It's buried in convoluted definitions or language in the main contract or one of the reimbursement exhibits. But clearly, that not only affects the bottom line, but it could affect the accuracy if the provider is the one having to constantly update how much it's actually going to cost. That's for another day. Back to the issue of disclosing pricing and quality information. To the extent it's not spelled out in detail by the law, and it often isn't, how will pricing and quality metrics be defined and determined in the contract? How will this information be presented to the public? What if it's presented inaccurately? Can the provider correct the information? You know, obviously all of this could have a tremendous impact on the provider. So contract language needs to protect the provider by ensuring that any representation of provider cost is relevant and not misleading. This applies to quality. Language needs to protect the provider to ensure that any representation of quality, whatever that is relevant and not misleading. And the quality issue isn't just about reputational damage to the provider, which is a huge issue, but it also impacts the provider's bottom line when reimbursement is based on achieving certain quality metrics. So it's really important there as well to delineate what that means and make sure it's relevant and accurate. Remember, I said earlier that payers may want to control this process of price and quality transparency. And the question is, why wouldn't they? They have all of the information on provider pricing and discounts. They control the benefit design, which ultimately dictates out-of-pocket cost. So with all of that and the law requiring transparency, payers could control the pricing and quality narrative about you, the provider. And the means by which they would do that is through the language in your contracts, which again underscores the importance of the provider contractually having a strong role in this process.
Thanks, David, for sharing that insight. Now we're going to move on to the third and final goal of the executive order and talk about the impact around that. So that's around the ultimate goal here, which is to increase transparency to lower costs. So Greg, what are your thoughts here?
Yeah, so the White House has noted that as it relates to increased pricing transparency leading to lower costs, it's important to note that healthcare providers are not alone. The pharmaceutical industry is as much a target for increased pricing transparency as providers. It's probably an area that has caught probably more media attention than our specific industry from a provider standpoint. It's important to note the last bullet point that the White House provided as they outlined their goals, and that is that prescription drug pricing decreased for the first time in nearly 50 years. Now, it's important for us to remember that the end goal is to lower cost. And the fact of the matter that drug prices actually decreased is likely going to be an indication of a tipping point for an increase expectation of real change in both industries. The fact that the White House has been able to talk down and cap, not just cap and control the rate of increase, but actually change it to see a downward step, I think is something we all need to take note of and be prepared for, that they will be looking for a similar downward step in our industry as we go forward.
Yeah, that's a great point, Greg. And I think Secretary Azar has been very clear about that since the beginning, even before the mandate to publish standard charges came out, that this was the ultimate goal, is to lower cost. And by giving patients more access to information creates more competition and allows people to make more informed decisions in order to drive competition. So it sounds like a simple concept, right? But my guess is there are probably some potential pitfalls that we should be aware of. So David, what are your thoughts around this?
So thank you, Brad and Greg. Just talking about the greater shift to patient, financial responsibility. With this change to much more consumer-driven benefit plans with huge deductibles and out-of-pocket maximums, providers have to be looking at different ways to counter the AR problem that this is causing. Now, back in the day, it was reasonable to have to wait until after the service was provided and the claim processed, but obviously things have changed. One thing to look for is restrictions, for example, on upfront collections and deposit requirements. Even if there's nothing in the contract about this, there should be. It's preferable, by the way, that anything that matters to you as the provider be addressed in the verbiage of the contract rather than in payer policies and procedures, which tend to be modified, at the discretion of the payer. So related to this is that you can't always assume that you can collect from members for denials based on a determination that services were not covered under a particular benefit plan. And I've seen a trend toward payer language and policies that creates increasingly complex and burdensome notice requirements for providers to even be able to collect from patients even when the services may be clearly non-covered. And I like to say, have you checked your AOB forms or financial responsibility language lately? And I've reviewed a number of these which haven't been updated in a long time, and I've seen it come up, with respect to another and interesting and somewhat disturbing trend called reference-based pricing, which some of you may have experienced. And I'm not going to digress on that topic now, but I've helped clients deal with this issue, and the language in the AOB has been raised as one of the components of how certain payers feel that reference-based pricing is allowed. It's clearly a problem, and it's hard to tell whether it's going to fully take hold, but if it does, that could be a big game changer in payer-provider relationships. So ultimately, with this new benefit plan paradigm, there has to be contract language that allows provider flexibility to work with and incentivize members to pay large patient responsibility amounts. But I always say be careful with waivers of patient responsibility amounts. I've worked with PFS departments to come up with effective solutions to minimize AR, but you just need to be aware that with respect to waivers, they might be prohibited by federal and state laws, depending on the circumstances, as well as the language of the contract. So continuing to the next slide, payers are obviously selling benefit plans that have dramatically shifted the payment burden to members, which has shifted, consequently, the collection burden to providers in a huge way. And the paradigm has been completely changed by payers, so I would think it's reasonable to look at ways in which payers can take on some additional responsibility for this. So, consider negotiating contract language to minimize bad debt. Maybe require payers to share this risk in some fashion, or how about an obligation to encourage their members or require to pay this patient responsibility amount that they owe you, that is effectively being set up by the way these payers are designing their benefit plans. There are numerous ways to address this issue in the contract. Hello?
Great points, David.
Thank you. Sure, go ahead.
Payer contracting strategies, both from a legal perspective and a financial perspective, need to continue to evolve to address these new considerations. As an accurate allowable has traditionally been viewed as the starting point for the payer negotiation process, the industry and the related revenue cycle processes are changing and will be evolving. Your charges are now transparent with everything being posted online. Based upon the executive order language, your payer contractual allowable may also be a new transparent requirement in the very near future. But regardless of whether your allowable is posted in a similar fashion to your CDM file or your average charge per DRG, the accuracy of your payer contractual reimbursement, the allowable, will be taking on a new level of importance as patients are becoming a larger portion of your organization's revenue cycle. David made some fantastic points about minimizing debt as you're working through that negotiation process. An accurate allowable helps ensure all payers are paying correctly and completely. It's coming full circle as hospitals are considering lowering some or all charges, and those adjustments must be modeled through the actual contracts. As you develop your new payer contracting strategy, and we think all hospitals need to really begin thinking in terms of your new contracting strategy, it's important to start with your payer scorecards and your prospective contract modeling processes. You need to assess your current benchmarks and really determine which ones are still relevant and which new ones need to be added to your process.
Greg, great points. You're absolutely correct. Payer contracting is not a static process. It's dynamic. Regardless of the final rulings that come out of the executive order, everyone needs to re-engage with hospital leadership, revenue cycle, and managed care to determine your payer contracting strategy. And I like to say that benchmark analysis is very important, but it's critical to do a detailed analysis of contract language because the variance in projected versus actual revenue increase often comes down to what the payer is able to control or modify by the terms of the contract, which includes the various reimbursement and other exhibits.
Great. Thank you, Greg and David. We are going to shortly wrap up today's session. But before we do that, I'm going to re-ask the same poll question that we asked in the beginning of the session. So now that we've more thoroughly discussed some of these topics, what is your biggest concern now regarding the executive order? So same question and same options. Inability to provide out-of-pocket costs to patients, the fact that we may have to publish contractual allowable amounts, the fact that we're not currently strategically planning for upcoming changes, or you believe this won't impact your organization. So again, what's your biggest concern about the executive order? Is it the fact that you have the inability to provide out-of-pocket costs to patients? The fact that you may have to publish contractual allowable discount prices? Maybe it's that you're not strategically planning for upcoming changes, or you believe this won't impact your organization. And we'll give everybody another 15 to 20 seconds here to get their votes in before we move on to closing thoughts. All right, thank you everybody for voting. At this point, Greg and David, we'll move on to closing thoughts.
Great. So first and foremost, I think the key takeaway from today's session is for everyone to go back and really review your current contracting strategy, your payer contracting strategy, which includes your payer scorecard process to ensure that you're capturing and monitoring the most current and potential future metrics. Denials may be an important metric today, and it may be important in the future. But the question you need to be looking at and asking others is, what additional metrics do we need to start to incorporate now? Because as we all know, you cannot manage what isn't measured. Along those same lines, a couple of other thoughts. One would be really know where you stand in the market with shoppable services. Cardiac arrest will likely not be a shoppable service, whereas high-tech imaging, ambulatory surge center services likely will be. CMS just announced some additional reimbursement changes to ASCs, so we'll continue to see a shift in that particular direction. Incorporate these thoughts as you go through to look at where you are in the market with shoppable services into your overall payer contracting strategy. Recognize the fact that your standard charges are public today, and that was just a first step and not the last step. And lastly, along those same lines, the patient financial responsibility or their cost is going to be directly tied to that negotiated rate. Their coinsurance amount is going to be tied to your allowable. This information, the allowable, in one way or another, will be public in the near future. Most patients still don't understand that retail charges are almost never paid. They see large contractual adjustments and think they're going to write off hundreds or potentially thousands of dollars, just write off my portion as well. We know in the industry that charges are really just an aggregation of what professional tasks, time, and other items were a part of that delivered healthcare service. Patients often don't fully understand the contractual relationship between the providers and the payers, and the fact that their insurance company negotiated a discount price or allowable on their behalf. This makes it even more challenging to make the connection that charges are priced high so that payers, being the insurance companies and the patient's employers, can receive a discount. We need to think about how to put this in terms of the cost for the patient and be prepared to upgrade our processes, our systems, and our contracts as we go forward.
Thanks, Greg. David, how about you? What are your closing thoughts?
I just want to say that even before you begin looking at new contracts to address some of the issues we've talked about, it's important to have a thorough understanding of your existing contracts and reimbursement language. You have to really understand what you have now and the issues you're facing because of it in order to better prepare for what you want to change going forward. Also, I've had situations where I've reviewed existing contract language. It's been around for a while, and it was thought to be or mean one thing, and we've been able to make a different interpretation, one that may not have been considered previously, and had success resolving issues with payers based on this new interpretation. Part of this is understanding and even anticipating, part of this whole process is understanding and anticipating new payer initiatives, and to be able to identify the must-have contract language that you need to put you in the best position in this new healthcare landscape, but also to remember that the language also that you want to avoid to minimize the variance in projected versus actual revenue.
Thanks, David. Great closing thoughts, I think, from both David and Greg. And at this time, we do have about 10 minutes left to take questions from the audience. We have a couple that have come in already. So if you do have any questions for us, please go ahead and enter those in the questions tab, and we will open those up for Greg and David. So the first question we have here, what would you say to hospitals who feel like their payer contracts are being cannibalized with price transparency and lowering prices?
I would certainly agree with your feeling that that's happening. And I would say that it is happening. It's probably not just a feeling, but it's the new reality that your services with increased pricing transparency and the move towards lower pricing and consumers actually shopping does have the potential for many providers to see their their business cannibalized by other organizations. That's why it's so important to really start to think about your payer contracting strategy with all of these points in mind. They're going to be disruptors because this whole process of pricing transparency is going to disrupt our industry. So I would agree with your comment that there will be cannibalization, and every hospital really needs to evaluate what services are you going to excel at and keep, and what services may become more commoditized services that you may be doing things differently than you're doing things today.
Greg, those are really good points. Those are really good points. I'd like to follow up on that. I think that underscores why it's so important to control the narrative and have input as a provider on this price transparency component and the quality component, because you need to be the one that's going to help set your facility apart. And it's not always just about you costing more for a certain service when in fact you may be lower in price on others, but it's all how it's portrayed to the public, maybe through the payer, to try to direct care a certain way, if you follow what I'm saying. So it's very important, because I've seen situations where, based on how the charge master is set, a certain procedure that isn't done very often at all, it may be actually very expensive, but that's not the high volume procedures that a particular facility is performing at a more reasonable cost. And let's be honest, there's more to it than just cost. Outcomes, quality considerations. So this is why it's so important now to be able to develop a message and be able to contractually articulate all of the aspects that set your facility apart. And to Greg's point, the lower pricing is part of the new world, but that's why setting payer contracting strategy to try to minimize any of the unanticipated reductions in revenue that are hitting facilities now because of the various complicated contract language and policy language, mind you, that reduces provider revenue in ways that were never anticipated.
Great points. Thanks, guys. Next question, and I can take this one, is can this presentation be accessed, and if so, where? Absolutely. The slides will be sent out to everyone this afternoon. We're also recording today's session, and so that link will be made available in the next couple of days. So next question we have, and this is I think a really good one for both Greg and David. Can you address how the confidentiality of rates may play out in this situation?
Sure. David, I'll take the first stab at this one. So with the confidentiality of rates, in all contracts, you've got language that federal law, is going to take precedent. So if there's a ruling that comes out that states that your allowable is now going to be mandated as being public information, that's going to override your contract and lead to, and David touched on this earlier, it's going to lead to payers coming back and probably proposing language in your contracts to address that piece. So we would certainly anticipate there being a conflict, but the federal law will override your contractual agreements.
Thank you. Great points, Greg. I look at what I see now in all of these agreements I see, and you see a provision or provisions that essentially say everything that we, the payer, put together and that talks about us is confidential. However, we, as the payer, have the right to disclose cost information or reimbursement information as we deem fit to our members and to the public. And this is the battle that I talked about that's so important, but now even more so because they're going to have the weight of the law behind it. So if for some reason someone doesn't like that in some capacity, payer or provider, there may be challenges. There may be lawsuits filed in this regard, and I wouldn't be surprised at all if there were. But at the end of the day, I think it's an inexorable march towards transparency, but it needs to be accurate and it needs to be relevant transparency.
Great. Next question, and David, I'm going to direct this one toward you. When should we start discussing this all with our payers?
It should be as soon as possible. Things are happening so quickly. The thing you don't want is to be caught off guard. And I've seen this too many times where it's a sort of a fire drill scenario. And unfortunately, in a lot of the agreements I've reviewed, the payers kind of seem to have the upper hand in how these things are going to flow and how they're going to move forward, or if any changes, depending on the terms, how they're going to be implemented. So the sooner the discussions begin, the better, because it allows you, the provider, to have a plan in place, to strategize, and to come up with the best strategy going forward to deal with this, quickly changing healthcare landscape.
Yeah, I would reiterate David's point of sooner rather than later. The executive orders laid out some specific timeframes, 60, 90, and 180 days. In your routine meetings, and you should be meeting with your payers probably monthly, if not quarterly, you should be bringing these questions up to your payers with what their direction is, what their thoughts are, where they're headed with this, just so that you're keeping that line of communication open, and it's a very level playing field in terms of the dialogue that you have. The other thing to note is you want to start now in beginning to escalate these discussions. So you may be working with your provider relation rep today on a very routine, regular basis. You probably want to start to escalate up to the VP level and even higher up within the payer organization to really make sure you've got a good personal relationship with all the people involved. Because, again, these things are going to be happening over the next 6 months, and you need to be having those discussions now, not waiting until it's law and then having to deal with it after the fact.
Yeah, great points. And another question, similar, and David, again, I'll direct this toward you first. What are your thoughts on how we should approach this with the payer?
Well, I think there's two ways to look at this. Is, you have obligations as providers and you have objectives as providers. And obviously you want to fulfill your obligations and your objectives. But I think there's also a component to this that's collaborative, that is an important, and it shouldn't be neglected, aspect of this. This is going to be across the board. There are things that payers and providers are going to have to do. It would be better to be able to work together collaboratively, but I always say fairly, in a mutually respectful way, where the provider is getting the input and the ability to control the portion of the process that applies to the provider. So I think that is how I would approach it. And again, it depends on your relationship, but hopefully that's helpful and answers the question. If not, you can follow up.
Yeah, I agree with David, your feedback and comments.
Great, thanks guys. And this is more of a comment, and maybe Greg, you can speak to this. The comment was made that in July, a federal judge ruled that the Trump administration cannot require drug companies to disclose charges in the advertisements of their products. Greg, what are your thoughts to that?
Yeah, so keep in mind that there are a couple of things here with this statement. The first is that the disclosure was with charges, and we need to go back to, we've got to embrace the fact that there is a charge, there's a price, and there's a cost. And ultimately what pricing transparency is moving really the whole healthcare system towards is greater transparency. There will be, I guarantee you, there will be plenty of lawsuits around different components as this transition occurs. As I said earlier, there's a lot of disruption that's going to take place, and the courts will be one avenue where a lot of this will get sorted out. But regardless of how it's sorted out through the courts with some of these minor components, the bigger piece that we've all got to embrace is that change around pricing transparency is going to be happening. There may be minor components around what can or cannot be required in a TV advertisement, but that's going to be totally different than the industry having to embrace the fact that pricing, contract negotiations are going to be different as we go forward into the 2020s than it was in the 2010s.
Yeah, great.
Great point. I just wanted to follow up briefly on that. I've done work in the pharma area, and again, it's a murky field. To your point, Greg, what does that mean? Charges. You've got PBMs in the middle, of this that everyone knows that it's a murky relationship. No one really knows how the rebates work and what the true cost is. So until all that gets resolved, I think there are going to be more questions, and again, there'll certainly be more lawsuits.
Yeah, and we're going to take a couple more questions here as they keep coming in. Outpatient costs for services like imaging and lab are more straightforward than hospital costs, which have too many factors that can alter the cost. So how will hospitals deal with putting those costs out there for consumers? And a follow-up point, when complications occur, it's difficult to control what the costs will evolve to. Greg, what do you think here?
Yeah, great point. And it really gets back to your payer scorecards and your analytics. It is a very fair point that depending on the site of service, you can have basic services like an MRI, and you may have an MRI that's done in conjunction with other services. It's going to be up to our teams to really begin analyzing the data, understand what your mix is like, understand how often do you bill for one single image code, being that procedure code, and how many times do you bill that code with other things, so that you're communicating out to the patient a true picture of what their cost is going to be. So if we know, as an example, a colonoscopy is done only 20% of the time as a diagnostic colonoscopy, and 80% of the time it's done in conjunction with a polyp removal, we've got to be able to communicate that to patients so that they really understand what their anticipated cost is going to be, and we're not understating or overstating what those bundle services are going to be. I agree with the person's point that there's a lot of complicated components that go into this, and that's where we're being challenged to figure it out through analytics as we go forward.
And this is David. Just to follow up on those great points, Greg. Yeah, this is one of the issues with this whole concept. Individuals don't know what the various procedures are going to entail and the additional components to that. So when they're shopping, how are they going to? They don't have that clinical capability. You'd almost have to be sitting there with a physician going over your specific case. And even then, there may be things that pop up that would be unanticipated. So it does raise the question of how that would be portrayed. And I think just from a perspective of the provider being the one responsible for that, language in terms of protecting yourself, disclaimer language in terms of protecting yourself about the true cost of this is important.
Thanks, guys. Next question. This is a really good one. From an outpatient hospital standpoint, how can this even be operationalized when payment methodology is often not at the line item level, and even being able to pull data to identify at the CPT level seems illogical when we are paid a lump sum? As an aside, CMS themselves are heading more in that direction by bundling more and more. Thoughts around this?
Yeah, so we've got two attendees for sure thinking along the same lines around the complexity that we're dealing with and are going to have to really grapple with as we go forward. Obviously, it's going to tie back to analytics, and I think the point that's being made here, kind of that closing piece about the direction that CMS is going with bundling, the part that's coming into play more and more frequently is the alternate payment models, shared savings, bundle scenarios. And as we start to look at integrating our retail price, our discount price strategy, and start working with payers, we need to look at and begin thinking in terms of how an Expedia or a Travelocity bundles services together to allow websites to provide a bundle component. There are organizations out there today that are actually doing that type of bundled analysis. They're using Medicare data to come up with self-pay patient rates as a bundle service for everything. And so that's a self-pay or a cash price. We're going to have to, again, embrace that as we go forward, because CMS is definitely indicating they're moving this direction. So we've got to take that into our contract modeling process. We've got to look at that from an analytical scorecard process. And we've got to start thinking about it in terms of how are we going to model prospective contract terms, taking into account our actual billing history, what things do get bundled, what things don't get bundled, how are they reimbursed as we go forward, because that's going to all drive what that patient cost is. And I guarantee you, patients are going to be looking for the estimates to be as accurate as possible. So it's going to lead back to really having good modeling tools, good analytical tools to really drive that negotiation process, because that allowable, that negotiated rate, is going to be what drives your estimate.
And these are great points too. And Greg, and it makes me think too of all the ways in which the incentives to create the lowest cost by payers to providers, in spite of that, in fixed payment, by adding in and bundling additional things for which you were previously getting paid. So just something to think about.
Thanks, guys. We'll take another one here. Is the requirement to disclose our net pricing by payer to the public going to be allowed by the courts? I would guess this would be overturned.
Could you repeat that again, please? One more time.
So the question was, is the requirement to disclose our net pricing by payer to the public going to be allowed by the courts? I would guess that this would be overturned in the courts.
So my initial thought is it has the likely potential of being overturned in the courts. It'll probably be drugged through the courts for sure. But regardless of whether you're allowable or the actual full contract terms are going to be posted, I believe even through an estimate system, your allowable is going to be public in some form or fashion. If you've got a telephone number on your website today that says, please call in and we'll provide you with an estimate, you're checking and you're going to provide that patient with an out-of-pocket cost based upon your allowable calculation. If that scenario is a very simplistic request with a single code, someone can very easily back into what your allowable is. So one way or another, I think pricing transparency is going to be occurring. You know, there are going to be some finer details with what and how your net pricing by payer will be out in the public. But for sure, from a Medicare and a Medicaid standpoint, I would imagine that data is going to be more and more public available, just like the CPT procedure lookup tool that they're already pushing out there today. That information is going to be available public, and there are going to be similar requests and similar pressure for commercial payers to respond in a like-kind way.
And I'll just follow up on that. I think those are great points, and it's true. It could prevail under challenge, and you know, it remains to be seen. But already there are payer transparency tools that are out there that allow members. Now, this is maybe through the portal that you have to sign into, so it's for payer members only. But you can sit there and compare on many services the cost based on your benefit plan from going from one provider to another. But it doesn't encompass all services, of course.
Thanks, guys. And I want to take this one as well. Does the executive order address the payer's responsibility in transparency and lowering healthcare costs?
From the standpoint of the executive order did call out, and President Trump did call out both the payer industry, insurance companies, and providers. So we would anticipate in the rulings that will be coming out in August and September, there will be some direct language on what the payer's responsibility will be in terms of pricing transparency. We just think that it's important for providers to maintain their seat at the table, because if we sit back and say, well, we don't want to deal with pricing transparency, and the payers do step forward, you may lose your opportunity to really control that message. And that's the key piece that we're trying to make sure everyone is thinking about and really putting in place strategies today to deal with that piece. David?
Yeah, exactly. And I've said this numerous times during the presentation. I could see payers going, wait a minute, we have all this data. We already have transparency tools out there, many do. Why shouldn't we just handle this? You know, let us aggregate whatever data that we require the provider to give us, and we'll get the message out. And maybe there's see, again, you don't know how it's, because the devil's in the details. You don't know how this thing's going to shake out. But maybe it's, you know, we're the ones that will push this out to our members and allow them to have a greater understanding of what it's going to cost them. Because you know what, we're doing it anyway, and we have access to these, funky benefit plan designs and know how it's all going to shake out, leaving the provider in the cold. When, again, how important is it for you to be able to have a say in this narrative?
Thanks, David. And we're going to take one final question here. Will this give the payers more power, knowing what our rates are with other payers?
This is David. Yeah, I can speak to this. I think it cuts both ways. You can use an example of a hospital system that, how should I put this, maybe has negotiated a lower rate with a certain payer that may not actually be the dominant payer. Well, guess what's going to happen when they find out that they haven't been given the best rate? Now, maybe they can't officially, due to antitrust reasons, say, I want MFN, most favored nations, status, but do you think they're going to want equivalent or better rates? I'd say, yeah. I mean, that's pretty powerful. Now, it also goes the other way. If facilities, depending on their situation, find out that certain other facilities are getting a better deal on things, then it may encourage them to readdress, how they're getting reimbursed. I think that's why there's so much concern. It's on both ends. It's payers and providers are going, how is this going to hurt or help us? But I can see how it could hurt and help both, depending on the situation.
Yeah, I'll just close with the fact that keep in mind the executive order that went out, the administration is asking Health and Human Services, the FTC, the Treasury, Labor, Commerce, and the Attorney General's office to all look at this particular executive order. So there's a lot of brain and manpower being focused on this particular issue. So they're going to want to keep it as balanced as possible. In some ways, payers may get more power. In other ways, providers may have a little bit more power. The end game is to ensure that the patient, who's had very little power to understand what the cost is, the end game is for that end patient consumer to have more power, more insight than they have today. That's really what this is all about.
Yeah, and again, just that the payer, talking about more power, they have a lot of power already. If for some reason, the way this shakes out, they're the ones that get to really own this, then yes, they will have more power, because then they'll be backed by a law that says, you know what, it's your job to send the message out and to really educate your members, consumers, on what it's going to cost to go to hospital A, B, or C. And then there'll be more control and power in that regard.
Great. I think great closing question, great closing thoughts from Greg and David. We're going to wrap up today's session. I know we ran over, but I thought we had so many great questions and great discussion going on that I wanted to continue the conversation. And I want to thank everyone for attending today, and thank you for staying with us a little bit late. The slides will be going out to everyone shortly this afternoon, and the recording will be made available in the next couple of days.
And just to add one additional closing thought, there have been several comments and questions around sort of the analytics and the direction and the payer strategy. Based upon the feedback, we will be putting together probably a follow-up session to this, digging into a little bit more of the detail behind your payer contracting strategy. So we'll be sending some information out to all the attendees with a time and place for that next session. Thanks, everyone.
Thank you, everyone.
Thank you very much, everybody.